And now we move to courts and jurisdiction. Section objectives. 1. To explain the different types of jurisdiction a court must have before it can render a binding decision in a case. 2. To recall the rules related to the choice of venue. 3. Describe the dual court system structure. And 4. Identify the threshold requirements that must be met before a court will hear a case. Now we have to start off with a broad definition of jurisdiction. Jurisdiction is nothing more than the authority of a court to hear and decide a case. Types of jurisdiction. There are 3 types of jurisdiction that the courts have to be concerned with. First is in personam jurisdiction. Jurisdiction over a person is called in personam jurisdiction. Next is jurisdiction over property. Jurisdiction over property is called in rem jurisdiction. And last but not least is subject matter jurisdiction. Subject matter jurisdiction is a limitation on the types of cases a court can hear. Now, an important point not to forget, before any court can hear a case, it must have jurisdiction over the subject matter of the lawsuit and either jurisdiction over the person against the lawsuits being brought against, in personam jurisdiction, or over the property involved in the lawsuit, in rem jurisdiction. Now, I just want to emphasize this. In personam jurisdiction and in rem jurisdiction are somewhat interchangeable. However, subject matter jurisdiction is non-negotiable. If a court does not have subject matter jurisdiction, under no circumstance can the court hear the case. Let's discuss how courts exercise jurisdiction. A court can exercise in personam jurisdiction over residents of the state in which the court is located and anyone who can be served a summons. Now, as I'm sure you know, a summons is nothing more than an order to appear in court. A summons is used in civil cases, right, to ensure that the defendant shows up to defend against the claims against him or her. Now, the reason why a summons works so effectively is because a failure to defend, to appear to defend, is an admission of liability. And what this means is the plaintiff, the party bringing the lawsuit, gets whatever he or she is asking for, right, if you don't contest the charges against you. Now, I want to highlight the difference between a resident and a citizen. Now, this definition is based on the understanding that a person is a citizen of the United States. We're talking about specific states now, not the country. An individual is a resident of any state in which he or she maintains a domicile. This means it's possible to be a resident of multiple states. Now, being a resident grants no special rights or privileges other than the common law property rights afforded to all. Now, citizenship is a little different. A person is a citizen of the state in which their primary residence is located. Citizenship grants additional rights over those of residents, specifically the right to vote, to serve on a jury, to hold certain jobs like being a police officer, and to run for an elected office. Now, I want to emphasize this. While you can be a resident of multiple states, you can only be a citizen of one. Now, I'm specifically referring to natural people. A natural person is someone that is born of a woman. For those of you who've had Business 104, you'll probably recognize that I'm talking about the different forms of business ownership in this next explanation. Right? There are basically three forms of business ownership: sole proprietorships, partnerships, and corporations. Right? With both partnerships and sole proprietorships, the owner is the business and the business is the owner. Right? So all of the rules that apply to an individual, a natural person, apply to sole proprietorships and partnerships. A corporation is a different animal. A corporation is an artificial person separate from its owners. And because a corporation is an artificial person, the rules of citizenship are slightly different with regard to a corporation. Whereas a natural person can only be a citizen of one state, a corporation can be a citizen of up to 2 states. A corporation is automatically a citizen of the state in which it was incorporated. And then, if different, a corporation can also be a citizen of the state in which its headquarters is located. Now, I know this might sound a little confusing, so let me explain it like this. In the United States, there are no rules regarding where you must form your business, where you must incorporate, right? So it's very, very possible for you to be a New York-based business. However, you incorporated in the state of Delaware. Why? Delaware is known to have very favorable corporation laws, right? Very favorable corporate laws. It makes it easy to change your charter. It makes it easy and relatively inexpensive to form your corporation in Delaware. In New York, it's a little more difficult. It's a little more expensive. So if you form your corporation in Delaware, you're automatically a citizen of Delaware. However, if your corporation is physically based in New York, meaning the headquarters is in New York, you're also a citizen of New York. Now, you're wondering why this is important. The reason why it's important deals with how you initiate a lawsuit. There are 2 documents that are required to initiate a lawsuit. One is a summons, that's the order to appear in court to defend. The other is the complaint. That's the document where the plaintiff writes down all of the causes of actions he or she has against the defendant. Now, in order to initiate this lawsuit, a person must be served the summons and the complaint. Now, for an individual, this is really easy. You show up at their house, you knock on the door, boom, boom, boom. Are you Ronald Clare? Yes, I am. You hand me a letter, and then the process server says you've been served. Right? For an individual, very straightforward. Well, in order to sue a corporation, the corporation also has to be served. The thing is, with a corporation, the service must be made to a person who is authorized in the corporate charter to receive service. And generally, corporations don't publish this, right? So if you want to sue a corporation, they try and make it as difficult as possible, right? You figure out where the corporate headquarters is, right? You go to the front desk, you see the receptionist, right? And you tell the receptionist you want to sue the corporation. Well, the receptionist is very rarely authorized to receive service, right? So what's the workaround? How do we make it fair? Well, if you want to sue a corporation, all you have to do is serve the Secretary of State of whatever state the corporation is a citizen of. You provide them with 2 copies. One is placed on file. The other is forwarded to the proper party, because corporations are required to register with the Secretary of State and let them know who's authorized to receive service. So going back to our early example, if you have a Delaware corporation based in New York and you need to sue them, you can serve either the Secretary of State of New York or the Secretary of State of Delaware. Both of those would be deemed effective service and the lawsuit can proceed. A court can exercise in rem jurisdiction over property located within its boundaries. So this means that if property is located in New York State, a court located in New York State can exercise in rem jurisdiction over that property. If property is located in Texas, a court physically located in Texas can exercise in rem jurisdiction over that property. Now, situations do arise where you want to sue a non-resident defendant. To cover these things, every state has something called a long-arm statute. A long-arm statute is a state law permitting courts to exercise jurisdiction over a non-resident defendant if the court can demonstrate that the non-resident had sufficient contacts with the state to justify the jurisdiction. These contacts are referred to as minimum contacts. Let's talk about the minimum contacts. First, there must be continuous and systematic contact with the state. Continuous means more than once. Systematic means on purpose. Second, the defendant, the party being sued, must have benefited from the contact with the state. Third, the defendant must have availed itself to the protections of the state. And when we say protections of the state, it can be the laws of the state or services provided by the state, like law enforcement, like the use of roads that are maintained by the state. And finally, the defendant knew it could be sued in the state. Now, of the four, the last one, the defendant knew it could be sued in the state, is the easiest to satisfy. Why? If you engage in business, there's always a possibility you can be sued. You probably won't, but it's possible. That being the case, you knew you could be sued, not would be, could be sued in the state. By way of example, I have to share a story from law school with you. When I was in law school, my first year of law school, I discovered that it was really demanding. The hours were really long. Basically, it really sucked. My first class started at 8:30 in the morning. My last class ended somewhere around 5 o'clock. And because it was customary for instructors to give you 50, 60, even 100 pages to read overnight, and memos and other documents or case briefings to do overnight, immediately after your last class, you might run and get something to eat, and then you spend the next several hours in the library. I found myself leaving my house every morning about 7 a.m. and getting back home somewhere around midnight on a regular basis during my first year of law school. Now, because it was so rigorous, so demanding, didn't have the opportunity to do fun things like go to the gym, play basketball, work out in any way, shape, or form. Now, for the fall semester, this was not so bad because big holiday is what? Christmas. It's the winter time. We get to wear clothes. If your suit looks good, you look good. During the spring semester, it did become a problem. Why? What do we all do during the spring? Spring break. Well, because I was studying so hard, I started noticing that my middle was expanding and I was taking on the appearance of the Buddha. Short, fat, and round. Every night when I would come home, because back in the 90s TV was different, we had these things called infomercials. I'd see this infomercial for this thing called an Ab Roller Plus. Every night when I get home, that was all that was on TV. And the first 5 or 6 times I saw it, I didn't think too much about it because these people would sit down on this ab roller doing these crunches, and in 3 weeks, they go from looking like Buddha to having a six-pack. But you know, when you see something over and over and over again, even though it doesn't seem truthful, even though it doesn't seem likely, it begins to seem real. Now, spring break is looming, so what do? I call the 800 number and I order an Ab Roller Plus, $89.99. I remember the price. Week later, my Ab Roller Plus gets to my house, comes with a videotape. I don't know if you guys remember what those are. Put it in my VCR and I start doing the exercises. And during the first week, I felt a little something going on. Didn't see any different, but I was sore. During week number 2, I swore I saw something. In week number 3, I started stepping up my game. I was doing my crunches really hard, really fast. Problem is, during the 3rd week of possessing the Ab Roller Plus, while I was doing my crunches on a downstroke, the headpiece that held my head to the machine fell off. My head smashes into the ground and I fracture my skull, cracked it. My floor at the time was a linoleum floor. Well, I guess it's a linoleum cover over a concrete floor, so it was very hard. Fractured my skull. I missed spring break. When I get out of the hospital, get back to school, I go to my favorite law professor, John Cicero, and I told him what happened. And he looks at me and says, Ron, this is great. I said, what do you mean this is great? He says, well, now we can sue them. So he helps me draft my complaint. He helps me draft my summons, and we serve it on the company. Now, this company is based in Florida. In their answer, they make a motion to dismiss, citing that New York State does not have jurisdiction over them because they are a Florida-based company. They were incorporated in Florida, and the headquarters was in Florida. When I received their response, the motion to dismiss, I go back to my professor, and I said, what do we do now? He says, don't worry about it. Remember what we went over in class. I said, what? Long-arm statutes. So I gave him a blank look. So he comes back and he says, think about this. How did you find out about this company? I said, well, I saw the ad on TV. He said, how many times did you see it? I said, I don't know, it must have been 20, 30 times I saw the ad. He said, well, where's your TV? I said, it's in my house. Where's your house? In Manhattan. Is Manhattan in New York State? Yes, it is. So you have continuous and systematic contact, or the defendant had continuous and systematic contact with the state. Did the defendant benefit from his contact with the state? And I looked at him. He said, did you pay for the Ab Roller Plus? I said, yes. He said, so they had benefited at least one time. They got that $89.99 from you. He said, now, did the defendant avail himself to the protections of the state? I said, I have absolutely no idea. He said, well, how did it get here? I said, it came via UPS. He said, was it in a truck? I said, I presume so. It's a pretty big box. He said, did the trucks drive on the roads of New York State? I said, it must have, to get to my house. So that, and he said, so while they were on the roads, they were protected by the laws of New York State and the police of New York State to ensure that they were not robbed or harmed in any way. I said, I guess so. And he said, did they know they could be sued in New York? I said, well, that's the cost of doing business. There's always the possibility of a lawsuit. He said, so we got him. And we were able to sue this company in New York State, right, because of the long-arm statute that New York State had, and because they satisfied all 4 requirements of the minimum contacts. Now, I want to emphasize this point. Number 1 is critical. Continuous and systematic. More than once and on purpose. A single chance encounter. A company doing business one time in a state where it's unplanned would not be enough for a state to use its long-arm statutes. Let's talk about the jurisdiction of courts. Now we have to start off in the very beginning and talk about the difference between a court of general jurisdiction and a court of limited jurisdiction. Now, as we alluded to in the previous slide, there are two types of courts. Courts of general jurisdiction can decide any type of case. Courts of special or limited jurisdiction are limited to the subject matter they were created to try. In New York State, our court of general jurisdiction is the New York State Supreme Court. Any type of lawsuit whatsoever brought before that court can be decided by that court. In New York State, our courts of special or limited jurisdiction would be housing court, also called landlord-tenant court, family court, traffic court, probate court, and small claims courts. Each one of these courts can only hear the subject matter it was created to try. That's all they can hear. No more, no more, no more. So if you own a house and you have a tenant that you want to evict, you got two choices where you can go. You can go to the New York State Supreme Court because they can hear anything, or you can go to landlord-tenant court, housing court, right, to get that tenant evicted. If you got an issue with child custody, child support, or juvenile crimes, you can go to the New York State Supreme Court because they can hear anything, or you can go to family court. Now, the reason why you're afforded these two options is because it streamlines the legal system. It makes it faster, right, to have your case heard. Yes, 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 the Supreme Court of New York State is a general jurisdiction court, and they can hear anything at all. But if they heard every single case, how long would it take for them to get to you? Right? Already in New York State, we have the busiest court docket in the country. New York State hears more cases than all other state and federal courts combined. Right? So we're really busy. Right? So you might have a landlord-tenant issue. You got a tenant that you want to evict. And if we only had one court to hear this case, you could wait for 3-4 years before you could get rid of this tenant that's not paying rent. Because we have these courts of limited jurisdiction, it speeds everything up, right? For a couple of reasons. First, you have more judges to hear cases. Second, the judge and the clerks specialize. You know, judges are very smart. Judges understand the law. However, different issues are covered by different laws. When you have a judge who's a specialist, a family court judge, a housing court judge, a traffic court judge, they tend to understand that area of the law intimately, right? So they hear cases faster because they can resolve the issues quicker. So it's better. It streamlines the system. Now, real big point here. As the definition says, a court of limited jurisdiction is limited to the subject matter it was created to try. If you bring a lawsuit to the wrong court, that court cannot hear the case under any circumstance whatsoever. They have to send it to the proper court. They have to send it to the proper court. Now, once again, just to emphasize this point, if I wasn't clear enough, courts of general jurisdiction share jurisdiction with courts of limited jurisdiction. But courts of limited jurisdiction do not share jurisdiction with one another. Courts of original jurisdiction versus courts of appellate jurisdiction. Courts having original jurisdiction are courts of the first instance. Trial courts are courts of original jurisdiction. The key feature of trial courts are there is one judge and a jury. The judge's job is to speak the law. Facts are introduced at this stage, and their validity is determined by the jury. Important point. A court having original jurisdiction can be either a court of general jurisdiction or a court of limited jurisdiction. The only thing that matters is that this is the very first place the lawsuit can be brought. Courts of appellate jurisdiction. Courts having appellate jurisdiction act as reviewing courts. They review the judgments of lower courts on cases brought to them on appeal. Appellate courts can overturn, concur, or remand the case back to the lower court. Overturn means they reverse it. Concur means they agree. Remand means there's a minor procedural matter that the lower court can resolve. Appellate courts are always courts of limited jurisdiction because they're limited to hearing appeals, the appeals of lower courts. Now, key features of courts having appellate jurisdiction are: 1, there is no jury. The jury is replaced by a panel of judges. The reason why there is no jury is because, as a general rule, facts are only introduced at trial. On appeal, no new evidence is introduced as a general rule. The only exception occurs in a capital case. A capital case is any case having a possible death sentence. If someone's life is on the line, evidence can be introduced at any time. But otherwise, evidence is not introduced on appeal. Because on an appeal, what the parties are arguing is that the lower court judge made a mistake in his or her interpretation of the law. Further, that the mistake made by the lower court judge impacted directly on the outcome of the case. For example, when a judge rules on testimony, you have an attorney questioning a witness, the other attorney is concerned about the questions, so the attorney objects. The judge rules on that objection. They either sustain the objection, meaning that the questions are no good, you have to ask something else, or they overrule the objection, meaning that you can keep on asking your question, right? The objection was incorrect. That's the judge speaking the law based on the federal rules of evidence. In order to prove a case, frequently attorneys introduce evidence at trial. The judge's job is to determine whether or not the evidence is admissible. Once again, it's based on the judge's interpretation of the federal rules of evidence. Sometimes a judge might direct a witness to not answer a question or to answer a question. Sometimes a judge may direct the jury to disregard the answer that a witness gave, right? Every time the judge speaks, he or she is interpreting the law. Well, on an appeal, the side that brings that motion is arguing that the judge ruled incorrectly. Had the judge ruled otherwise, the outcome would have been different. Now, because the arguments on an appeal are technical arguments, the truth is not at issue here. So the jury has no place because the jury is not made up of lawyers, but lay people, people with other skills. So in order to determine whether a judge interpreted the law correctly, what do you need? You need experts. So in their place, you have judges. Right now, you always have a 3-to-1 ratio with judges. At trial court, we have one judge. In your court of intermediate review, your first appeal, we have 3 judges, right? 3 judges decide whether one judge was correct in his or her interpretation of the law. Now, why do you have 3? Well, if you just had one judge reviewing the actions of another judge, he or she might get it wrong. If you had 2 judges, they might get deadlocked because they disagree. When you have 3 judges, an odd number, the majority rules. If 2 judges say that the lower court judge was correct, they concur with that decision. If 2 say the lower court judge was wrong, they overturn that lower court decision. Now, as I said, this is your Court of Intermediate Review. In the United States, you're entitled to 2 appeals. Now, the second appeal we call the Court of Final Review. This is going to be the highest court in whatever legal system you're in, whatever state you're in, right? It's the Court of Final Review because generally there's nowhere higher to go. Now, as I said, you always have a 3-to-1 ratio on appeals. So in your Court of Final Review, you have 9 judges, now called justices, that review the decision of the court immediately below them, the Court of Intermediate Review, where you have 3 judges to determine whether or not their interpretation of the trial court judge's interpretation of the law was correct. And they can do exactly the same thing that the Court of Intermediate Review does. They can overturn that court's decision, they can concur with that court's decision, or they could remand it back to them. Now, we've been talking about jurisdiction up to this point. Now it's time to talk about venue. Venue is concerned with the most appropriate location for a trial. A court may have jurisdiction, but not venue. But unlike jurisdiction, venue is negotiable. And that's because proper venue is established by statute. There are a few key points we have to cover regarding venue. A proper venue does not necessarily deprive a court of the power to try a case. Now, as a general rule, proper venue is where the cause of action occurred. The cause of action is a set of circumstances that cause the lawsuit to be brought. The idea behind this has multiple moving parts. First, what does it take to prove a case? Generally, witnesses and evidence. Where are witnesses and evidence generally located? Where the cause of action took place, right? If somebody is hit by a car in Manhattan, who saw it? People who were there, people who were physically in Manhattan. Where's the evidence? Where the cause of action occurred, where the accident happened in Manhattan. What do we know about evidence? The further you move it, the more people that touch it, the greater the likelihood that it could be lost or contaminated. What do we know about witnesses? The easier it is for them to get to a trial, the more likely their participation will be willing. Another factor, where does the jury come from? The jury comes from where the trial takes place. If the trial takes place where the cause of action occurred, the idea is that the jury will be more attentive because they've got a vested interest in the outcome. Whatever they decide could affect them. If there's a accident in Manhattan, somebody gets hit by a car while riding their bike because there's a problem with the traffic lights, and the city of New York is part of that lawsuit, right? The people who could be affected by it will be more focused on changing the law to benefit them personally, so they'll be more attentive. Now, with that said, situations do arise where trial will take place in a proper venue. Now, the first situation comes up for strategic reasons. The plaintiff is the moving party, the party that brings the lawsuit. The plaintiff gets to decide where to file the lawsuit, what court to file it in. And sometimes you have courts that do in fact have jurisdiction over a lawsuit, although they're in the wrong place. I call your attention to this fact that we went over just a little while ago. A court has in personam jurisdiction over the residents of the state in which the court is located. A court has in rem jurisdiction over property located in the same state as the court. Now, coming back to New York, If something happens in New York City, specifically in Manhattan, a court in Albany, a court in Buffalo, a court in Rochester would have jurisdiction. Why? Because all of those cities are located in New York State, meaning those courts are located in New York State. So they have jurisdiction over everybody and all the property in New York State. Now, as I said, the plaintiff, the moving party, the party bringing the lawsuit, can select what court to file a lawsuit in. And sometimes, smart attorneys are going to look at factors that will impact directly on the outcome of the case to benefit their client. All right, let's say you have a young man. Let's make him Afro-Latino, riding his bike up Amsterdam Avenue. He gets hit by a car on 112th Street. Closest hospital is St. Luke's. They take him into the hospital because of the damage his left leg sustained. They decide the only way to save this young man's life is to cut off his leg. They schedule him for the surgery. When he gets into the operating room, the doctor who's about to operate on him has been up for 36 hours. When he looks at the chart to see which leg he's supposed to cut off, his right leg, instead of reading RT, he reads LT. So he goes in and he removes the left leg. As they're about to take him out, the anesthesiologist, another doctor in there with him, says, "Oh my God, man, you've cut off the wrong leg. This young man's still going to die." So they take him back in, and the doctor cuts off the right leg. The young man went in with 2 legs, was supposed to leave with 1 leg. He leaves with no legs. What are you going to do? You're going to sue the hospital. You're going to sue St. Luke's. You're going to sue the doctor. You're going to sue the nurse. You're going to sue everybody in an effort to recover the loss of your limbs, or financially recover the loss of your limbs. Now, here's the thing. St. Luke's Hospital is located in Manhattan. Proper venue is New York State Supreme Court, located in Manhattan, down by the college. But here's the thing. Juries from Manhattan have 2 features that may not benefit my client. As I said, my client is an Afro-Latino teenage male. He's 18 years old. Most juries in Manhattan are overwhelmingly educated, professional people, and overwhelmingly white. Now, why does this matter? Well, here's the thing. You have a right to a trial before a jury of your peers, because these folks can relate to you. They can understand how you speak, despite how you look, despite an accent you may or may not have, despite your speech pattern. They can get past that because they know people like you, right? They can go beneath the surface. Also, as a lawyer, I don't really want professional people on this jury, because professional people are very good, but they like things like facts, and sometimes facts get in the way for a good settlement for my client. Real big fact they'd be concerned with, yes, it's a travesty this young man lost his legs, but what is he worth? Now, as I said, we got an 18-year-old who was riding his bike. Let's say he was on his way to work to Burger King. He made $150 a week. How much is he worth? What are his legs worth? Well, it'd be 150 times 52 times 45. Why? What do you make a year times his working life? Now, I'm not going to do the math because I just threw those numbers out, but let's say that comes out to being something like $4 million. That's what he's going to get, $4 million for the loss of both legs. That's not a lot of money when you lose your legs. Now, if I file this case in the Bronx, where the demographics are a little bit different, the Bronx is more ethnic, the folks are more blue collar, they are swayed by emotion more than facts. So up in the Bronx, when I'm talking to the jury, I can talk about how this young man was working hard, trying to help his mother support his 3 little sisters, because his father was killed while serving this country in Afghanistan. I can talk about how this young man graduated first in his class in high school, and had been accepted to Columbia University on a full scholarship with a dream of becoming a doctor. More specifically, he wanted to deal with medical engineering. He wanted to make biotic arms and legs to help wounded warriors. I can emphasize how this doctor couldn't be bothered to read a chart correctly, who incidentally graduated from both Columbia and Harvard himself, because he was more concerned with getting to his country club. I could say all these things. Now, the emotional impact of that would probably supersede the actual value of this young man, because unfortunately you're judged by what you're doing today, not what you might do in the future. And the award in the Bronx might be $20 million as opposed to that $4 million would have got in Manhattan. Better for my client. And also better for me since I get a third. But that's aside the point. Now here's the thing. If the venue is improper for strategic purposes, a party to the lawsuit can request a change of venue prior to the commencement of the suit, meaning that the defense can challenge it. In their initial answer to the summons and complaint, they can make a motion for change of venue to the proper venue. Now, if this motion is made, the case is moved to proper venue automatically. Now, if no objection to the venue is made, the defense forever loses its right to challenge the venue, and the case can proceed. So while I may not get in the court that I want to get to, it's something that I might get, so it's something I should do for my client to give him the best possible outcome. Now, the policy purpose behind venue is that a court should be located in the community in which the incident leading to the commencement of the suit occurred, because the community has a vested interest. With that said, there are also pretrial factors which may require that a trial be moved to a venue outside of the occurrence in order to ensure a fair trial. You have some cases that are highly politicized. Case in New York that comes to my mind is Amadou Diallo. Amadou Diallo was a young man living in the Bronx, immigrant to the United States. One day, while trying to get into his building, he is approached by 4 police officers, new to the community, who were looking for a drug dealer. Mr. Diallo apparently fit his description, as all young men of color in the Bronx appeared to back in those days. Mr. Diallo, being an immigrant, English being his second language, when he saw these 4 men with guns pointing at him, telling him, "Stop, police," he may have forgotten how to speak English, so he makes a mistake. He reaches into his pocket to pull out his keys to get into his house. And the cops shot him 41 times. They killed him. A lot of public outcry. There was a trial where the cops were charged with manslaughter. Problem was, while the trial was supposed to take place in the Bronx, there was no way those cops could get a fair trial, because just a little bit before Amadou Diallo was killed by the police, another young man, Anthony Baez, was killed by a police officer named Lavodi. Mr. Baez was playing football in the street with his cousin. Apparently his cousin threw the football to him. He failed to catch it. The football hits the police car, enraging Officer Lavodi. Officer Lavodi gets out of his car and puts Mr. Baez in an illegal chokehold, which ultimately kills him. Officer Lavodi elects to have a bench trial for his manslaughter charges, where he is acquitted. Folks were outraged, and by the time Amadou Diallo came, there was an idea that the cops were hunting young men of color, and there was no possibility for justice. They knew the cops were guilty. There would have been no fair trial. So what does the defense counsel do? They make a motion for change of venue on the grounds of fair play and justice. The case was moved to Albany, where they impounded an impartial jury who listened to the facts as they were presented, and they correctly acquitted the police. What had happened was a tragic accident. It was not something that the cops set out to do. The cops were not trying to hunt this young man, right? But basically you had 4 police officers who were brand new to the unit that they were assigned to and brand new to the neighborhood. They were giving a description with Mr. Diallo met, and they ordered him, stop, police. When Mr. Diallo stuck his hand in his pocket, police department training said, when a suspect goes for something, you assume it's a weapon and you defend yourself. So they believed he was coming up with a gun because the drug dealer they were looking for was known to be dangerous and armed. Now, folks say 41 shots is a long time, but the entire incident took less than 30 seconds. You had 4 police officers, each with guns, carrying 17 rounds. Nobody even reloaded, right? And when they started shooting at Mr. Diallo, the light conditions were not the best. He fell into the vestibule of his building, and bullets ricocheted back out at the police officers. One of the cops had a bullet hole in his pant leg. They thought Mr. Diallo was returning fire. And what does police doctrine say? You keep shooting until the suspect is down, until the suspect stops shooting at you. It was a tragic accident, but it was not a crime. Now, in a civil lawsuit, liability was assigned to the city of New York and the police department for failing to properly supervise these police officers. Right? So Amadou Diallo's mom walked away with $24 million, which does not compensate her for the loss of her child, but it was something. And she donated quite a bit of that money, right, to to groups trying to fight for reform with the police department, something that we're doing today. Now, the silver lining to this awful, awful story is that after Amadou Diallo, a look was taken at how police officers in New York City were being trained and the makeup of the department. All 4 cops that went to the Bronx were white guys that lived in Long Island. They were not familiar with the neighborhood or the people, the ebbs and flows. And the police department decided that to be more effective, the force should more closely reflect the city that it polices. The idea being, if people come from a common background, they can pick up cues. Right? Not wanting to sound like a bad person, but if you stop and think about this, people who come from the same environment, the same countries, the same communities, know each other better. You can pick up threat responses. You can pick up who's who, right? And that was the idea. So if you look at the police department today, right, it's much more diversified. We have more women in leadership, which is good because women tend to be a cooling factor, right? And why are women a cooling factor? Women tend not to have to prove that they're tough guys. They tend not to be macho. They tend to be smarter. Women tend to solve problems where guys go in one to bust heads. So female leadership has led to a cooling and a more thoughtful police department as well, right? That's the silver lining. But that's just an example of where improper venue was necessary for fair play and justice. Let's talk about the structure of our court system in the United States. Basically, we have a 3-tier court system. We have trial courts as tier 1, courts of intermediate review as tier 2, and courts of final review as tier 3. Now you'll notice from the screen, it's a pyramid. Lots of trial courts, fewer courts of intermediate review, and only 1 court of final review. Now, important to note that the federal system and the state systems are identical in structure. Names change, but functions are the same. The names change, but the functions are the same. Let's talk about the New York State Court. Our Tier 1 court, our court of original jurisdiction, our trial court. These are generally the first courts to hear a case. On this level, there are both courts of limited jurisdiction and general jurisdiction. In New York State, the Court of General Jurisdiction is the New York State Supreme Court. Family Court is an example of a court of limited jurisdiction. Tier 2 in New York State. This is our Intermediate Court of Appeal. The subject matter jurisdiction of courts at this tier is limited to hearing appeals from lower courts, the courts of original jurisdiction. An appellate court examines the record of the trial court to determine whether or not the trial court committed any errors. This court looks at questions of law and procedure, not facts. This is the reason why, as a general rule at this level, no evidence is introduced. The arguments are based on the court transcripts. In New York State, the New York State Supreme Court Appellate Division is our court of intermediate review, right? In this court, once again, we have 3 judges that review the actions of the lower court judge. Tier 3, the State Supreme Court. The subject matter jurisdiction of this court is also limited to hearing appeals from lower courts, with the exception of a capital case. Once again, a capital case is any case that carries a possible death sentence. The decisions of the court at this level are final, with the exception of federal questions, which can only be ruled on by the Supreme Court. Right now, for all intents and purposes, this is where it stops in a state level. There is no automatic appeal to the United States Supreme Court. In order to get to the Supreme Court, once again, there must be a federal question, and the party making the appeal must request that the U.S. Supreme Court issue a writ or certiorari, which is an order to the lower court to send the record to the Supreme Court for their review. If it's something they want to deal with, they'll hear the case, but there is no guarantee. With the Supreme Court, it must always be issues of national significance, because once the U.S. Supreme Court decides something, it becomes the law for the entire country, not just the state. In New York State, this court is the New York State Court of Appeals. Now, once again, we step up the number of judges from 3 to 9. We always have a 3-to-1 ratio. And once again, at this level, the judges are referred to as justices. Okay, this is a slide of the structure of courts in New York State. I don't have a lot to talk about. You can read this one yourself. The federal court system. Tier 1 courts of original jurisdiction, right? Now, once again, these are the first places that a lawsuit can be brought. And on the federal level, right, it's going to be the United States District Court. The United States District Court. Now, our courts on Tier 1 of limited jurisdiction would be the United States Bankruptcy Court, the United States Tax Court, and the United States Court of Federal Claims. Right? These courts are limited to hearing cases based on what they are created to try: bankruptcy, tax, and federal claims. On a federal level, the Court of Intermediate Review is the United States Courts of Appeals. Right? Once again, this is a court of limited jurisdiction, limited to hearing appeals brought to them from the lower courts, the courts of original jurisdiction. Now, this one should come as no surprise. Our Tier 3 court in the federal system is the United States Supreme Court. This is the highest court in the country. Now, as I said, while all Americans are eligible for 2 appeals, on the federal level, you'll get 1 appeal. You might get the second one, because once again, if you want the Supreme Court to review your case, you have to request that the Supreme Court issue a writ or certiorari, which is an order to the lower court ordering them to send the records up for their review. The Supreme Court is allowed to decide what cases it wants to hear, And this is important because anything they hear, once again, must be of national significance, because when the Supreme Court rules, it becomes the law for the entire country, not just the state. So it applies to more than just that single case. This is a chart highlighting the federal court system. Exclusive jurisdiction versus concurrent jurisdiction. Concurrent jurisdiction exists where two or more courts from different systems simultaneously have jurisdiction over a specific case. In the United States, concurrent jurisdiction exists to the extent that the United States Constitution permits federal courts to hear actions that can also be heard by state courts. Exclusive jurisdiction exists where one court has the power to adjudicate a case to the exclusion of all others. Due to the limitations that the United States Constitution places on the federal government, state courts can hear a wider range of cases than federal courts. Generally speaking, if a lawsuit is based solely on state law, federal courts cannot hear the case. However, with a few exceptions, if a lawsuit is based on federal law, state courts can try the case. The jurisdiction of federal courts. Federal courts have jurisdiction over suits in law and equity arising under the Constitution of the United States, the laws of the United States, and treaties made or which shall be made under their authority. When a suit is based on these conditions, a federal question arises. Federal courts have jurisdiction over lawsuits involving diversity of citizenship. Diversity of citizenship occurs when the parties are 1, citizens of different states, and 2, the amount of controversy is more than $75,000. Now, if diversity of citizenship occurs, the lawsuit can be over anything whatsoever. Now, the areas where the federal government has exclusive jurisdiction are as follows: admiralty cases, bankruptcy cases, federal criminal prosecutions, cases in which one state sues another, claims against the United States, federal patent, trademark, or copyright claims, and other claims involving federal statutes that specify exclusive federal jurisdiction.